Millions of immigrants living in the United States have just received news that could significantly change their day-to-day situation. And understanding exactly what has shifted, why it matters, and what you still need to do on your end could make a genuine difference in your life. The United States government has introduced new measures through which certain immigration benefits and protections are now being processed automatically. That means no extra paperwork in many cases, no repeat applications, and no rushing to meet tight deadlines that arrive on top of an already stressful situation. In a growing number of circumstances, the system is now designed to take care of critical extensions and continuations on your behalf, provided you have already done your part correctly. If you have been stuck in immigration backlogs, waiting endlessly for updates that never seem to come, or worried about losing your work authorization because of delays that were never your fault to begin with, this update is especially important for you, and the details are worth understanding carefully and completely. To appreciate why these changes matter so much, it helps to understand the problem they are trying to solve, because that problem has been serious, widespread, and deeply damaging to the lives of real people for a very long time. One of the biggest and most persistent issues in the United States immigration system has been the chronic delays in processing employment authorization documents, which are commonly referred to as EADs. These are the work permits that allow immigrants to legally work in the United States, and without them, people cannot hold jobs, cannot maintain income, and in many cases cannot access the healthcare and financial stability that employment provides. For years, the agency responsible for processing these documents, known as USCIS, has been overwhelmed with the volume of applications it receives. Processing times have stretched to extraordinary lengths, running into 14, 16, and sometimes even 18 months depending on the specific category of applicant involved. That is a year and a half of waiting in some cases. And the problem is that EAD cards expire on a fixed calendar date regardless of how long the government takes to process the renewal sitting on its desk. The result of that mismatch has been a gap, and that gap has caused devastating consequences for people who did absolutely nothing wrong. Someone applies for their renewal well in advance, follows every instruction, submits every required document, and pays every required fee. Then they wait, and their card expires, and still they wait. And during that waiting period, they find themselves in legal limbo where their authorization to work has technically lapsed, even though their application is sitting in a government queue. Employers, understandably cautious about compliance with immigration law, have let workers go in these situations. People have lost jobs they were good at, lost the health coverage that came with those jobs, and faced financial instability that rippled through their households and families. None of it was caused by anything they did wrong. All of it was caused by administrative delays within a government system that could not keep up with demand. That is the problem that the latest policy changes are directly and specifically designed to address. The most significant and practically impactful change is the dramatic expansion of the automatic extension period for certain EAD renewals. Under the updated policy, if you file a timely renewal application using the correct form, which is Form I-765, before your current EAD expires, you may now receive an automatic extension of up to 540 days. To put that in plain terms, that is approximately 18 months of continued work authorization that kicks in automatically without any additional applications, without any extra fees, and without any further action required on your part beyond what you have already done. You filed on time, you filed correctly, and the system now recognizes that you should not be penalized for delays that are entirely outside your control. The extension happens automatically if you qualify, and even if your physical card has already passed its printed expiry date, your work authorization can remain legally valid throughout this extension period as long as your renewal was submitted correctly and before the deadline. It is important, however, to be clear about what this policy does and does not cover, because the eligibility requirements are specific, and assuming you qualify without verifying that assumption could lead to serious problems. This automatic extension does not apply to every immigrant in every situation. It applies to people in eligible categories who filed their renewal before their existing EAD expired. If you filed late, even by a short period, the automatic extension does not activate. The timing of your filing is a hard requirement, not a guideline. The policy covers a wide range of applicants, including asylum seekers with pending cases, individuals living under temporary protected status, people who have filed Form I-485 as part of an adjustment of status application, and others in specific eligible categories that are listed and maintained on the USCIS website. If you are in one of these groups and you filed on time, then your expired physical EAD card combined with your USCIS receipt notice, which is the document you received confirming your application was submitted, serves together as valid proof of continued work authorization. That combination of documents is critical to understand and to keep safe. The receipt notice, formerly known as Form I-797, is not just a piece of confirmation mail to be filed away and forgotten. It is an active legal document that, together with your expired card, proves that you are operating under the automatic extension policy and that your work authorization remains valid. You should keep both documents together, accessible and in good condition at all times while your renewal is pending. Losing your receipt notice puts you in a significantly more difficult position when you need to demonstrate your continued eligibility to work. The legal obligations around this policy also extend to employers, and this is a dimension of the update that is just as important as the protections it offers workers directly. Employers are legally required to accept valid documentation of work authorization, and under the automatic extension rules, the combination of an expired EAD card and a valid receipt notice constitutes exactly that. An employer cannot legally terminate or refuse to hire someone simply because their card shows an expired date if that person falls within the automatic extension framework. Doing so could expose the employer to legal liability under immigration law protections. This means that if you are in a situation where your employer is confused about your status or is pressuring you because of an expired card, you have legal backing on your side. You are not in a weak position. The law is clear. And knowing that gives you the ability to advocate for yourself in a workplace situation rather than accepting wrongful job loss as inevitable. That said, many human resources departments across the country are still not fully up to date on how these automatic extension rules work in practice. The policy has evolved, the rules have changed, and not every employer has kept pace with those changes. Being proactive about educating your employer or HR department before a problem arises is far better than trying to resolve a misunderstanding after you have already been told your position is at risk. You do not need to approach that conversation from a defensive position. You can approach it as someone sharing important and relevant information that helps both you and your employer stay compliant with the law. Beyond employment authorization, there are also meaningful updates for green card holders who are dealing with expired or soon-to-expire permanent resident cards. If your green card has expired or is approaching expiration, and you have already filed Form I-90 to renew it, USCIS is now automatically extending the validity of those cards in many cases for up to 2 years. This automatic extension is typically confirmed through official notices or passport stamps issued under Form Y-551. For people who have been waiting anxiously about the status of their permanent residency documentation, this is a meaningful relief. The green card serves as the foundational proof of your right to live and work in the United States, and having that documentation lapse while a renewal is pending creates genuine anxiety and practical problems. The automatic extension policy addresses that gap in a direct way. Another substantial group of immigrants who are affected by automatic protections under recent policy developments are temporary protected status holders, commonly known as TPS beneficiaries. TPS has historically been a category marked by uncertainty, legal challenges, and the kind of administrative back and forth that makes it very difficult for recipients to plan their lives with any confidence. In many cases, court orders and government actions have resulted in automatic extensions of both TPS status itself and the work authorization that comes with it. These automatic extensions have applied to individuals from a range of countries, including Venezuela, El Salvador, Ukraine, Nepal, Honduras, and others, depending on the current designations in effect and the outcomes of relevant court rulings at the time. In a significant number of these situations, beneficiaries did not need to take any additional action to receive continued protection. The extension came through the legal and administrative process without requiring anything further from the individuals affected. For TPS holders, however, the situation has always been subject to change depending on political and legal developments, and that reality has not disappeared. What has changed is that the framework of automatic protections has become more robust and more clearly defined in recent years, giving beneficiaries a stronger and clearer legal foundation during periods of uncertainty. Staying informed about the current status of your specific TPS designation is essential because the details can and do change, and operating on outdated information can put you in a vulnerable position. Stepping back to look at the practical steps that all of this requires, the first and most important thing anyone in an affected category should do is verify their specific eligibility on the USCIS website. The website maintains updated lists of which EAD categories qualify for automatic extension, and checking that your category is included is not optional. It is a necessary step that protects you from assuming protections apply to your situation when they may not. If your category is listed as eligible, then the next priority is ensuring that you have your receipt notice, Form I-797, and that you know where it is. That document is the cornerstone of your ability to demonstrate continued work authorization while your renewal is pending, and you should treat it accordingly. Keeping your expired EAD card together with your receipt notice is not a small administrative detail. It is the practical combination that proves your legal status to anyone who needs to verify it, whether that is an employer, a bank, a landlord, or any other institution that requires documentation of your right to work and reside in the country. These two documents together tell the story of where you stand in the system and confirm that you are operating within the rules as they currently exist. There are, of course, limits to what these protections cover, and being honest about those limits is just as important as understanding the benefits. If you changed your eligibility category between applications, if you filed your renewal late, or if your case was closed for administrative reasons that affect your standing, you may not qualify for the automatic extension. These situations are not simple to navigate on your own, and in those circumstances, consulting with a qualified immigration attorney is not just a suggestion. It is a genuinely important step that can prevent you from making assumptions that lead to serious and difficult-to-reverse consequences. Immigration law is complex, circumstances vary significantly from person to person, and professional legal guidance exists precisely for situations where the standard rules do not clearly apply to your specific case. Looking at the broader context, these policy changes represent a meaningful acknowledgement from the government that the burden of processing delays should not fall on immigrants who have followed every rule. The underlying principle is straightforward and fair. If you did what you were required to do, on time and correctly, you should not lose your job, your income, or your legal status because a government agency could not process your application before your card expired. That principle has now been translated into actual policy in a more substantial way than it had been previously. And for millions of people living with the daily stress of immigration uncertainty, that shift is genuinely significant. However, these protections are based on agency decisions and court rulings rather than permanent legislation, which means they are not guaranteed to remain unchanged regardless of future political or administrative developments. There are ongoing conversations about whether some of these automatic protections should be codified into law to make them more durable and less subject to reversal, but nothing comprehensive has been finalized in that direction yet. For now, the protections exist and are in effect, and they provide real relief to real people. What that uncertainty about the future means practically is that staying informed matters more than ever. Policies that exist today may be modified, expanded, or challenged tomorrow, and the only way to navigate that environment effectively is to keep your information current and to pay close attention to official communications from USCIS when they arrive. The overall message that emerges from all of these changes is one that rewards preparation, organization, and engagement. If you filed correctly and on time, there are now automatic systems working in your favor that were not there before. That is a real and meaningful improvement. But those systems work best for people who understand how they operate, who keep the right documents in order, who communicate proactively with their employers, and who seek professional guidance when their situation falls outside the standard framework. Staying organized, keeping your documents updated, verifying your eligibility, and responding promptly to any official communication from USCIS are the practical habits that allow you to take full advantage of the protections now available to you. This update represents one of the most practically significant administrative improvements in recent years for immigrants dealing with delays and backlogs, and that is precisely why staying informed about it, sharing it with others in similar situations, and acting on it thoughtfully and promptly is so important. The system has moved in a direction that better recognizes the reality of what immigrants face when bureaucratic delays collide with fixed expiry dates. Understanding that shift, knowing your rights within it, and taking the steps required to protect yourself within it is how you turn policy change into real security in your own life.